Hello, welcome to Jurist Jargon. Just a quick reminder, we are not attorneys, so if you need legal advice, please seek out counsel in your in your local jurisdiction. My name's David.
And I'm Will.
And let's get on with the show.
So, first of all, the Supreme Court started a new session, and one of the first things that they're going to do is they're going to basically hand out a list of cases that they're not going to be hearing. We discussed this a little bit in our first episode, I think it was. The Supreme Court has discretion in which cases they hear. If you appeal from the appellate court, you're asking for a writ of certiorari, they call it. And so here we just have a few cases where the Supreme Court said, you know, we're not going to hear this issue. There's a lot of reasons for that. There's a few different doctrines at play that help guide those decisions. And depending on how cynical you want to be about the judge's motivations. And so I thought we'd maybe talk about that a little bit.
Well, why don't you get into the first one? The first one has to do with a drug, an MS drug coming from a company called Accorda. So can you tell us a little bit about that?
Right. So this company, Accorda, they have 5 different patents for this MS drug. And I say 5 different patents for this drug because what frequently has happened in the pharmaceutical industry is that you can extend your patent. If you create a new drug based on your old technology, you can keep the old technology protected. What this leads to is an adverse incentive where every few years when a patent's about to expire, they just redo the formula a little bit to maintain their protections and their patents over the whole chain of changes. And the Federal Circuit Court, I believe it was the 4th Circuit? It's New York, 2nd Circuit. They decided that there was no substantial change. That once they had their first formula, the 4 new patents were obvious from that. They didn't actually create something new. And so now this is going to open up the markets for generics of their MS drug to be sold.
And I just want to point out that this is a drug that was initially found, or a medicine that was initially found in 1902. So they've basically been maneuvering to have patents last for, 100 and almost 20 years.
Right, and that's an interesting point. The reason that we have patents, at least the theory behind it in the free market, is that you want somebody who invents something new not to be ripped off immediately so that they can actually benefit from creating something. It gives people a reason to invest in creation and new inventions. But we do eventually want people to more broadly benefit from that and for there to be more competition in the marketplace. So a patent's supposed to prescribe a time limit where you have the exclusive right to profit off of something before everybody can use it, before it just becomes common knowledge.
And excuse me, I don't think their patent was for 120 years, but that's how long the medicine's been around. And right. I think it is important to note, especially in the pharmaceutical industry, how important patents are. I don't want to deny how important they are because what people don't know about developing medicine is that, one, it costs, hundreds of millions of dollars to do. And oftentimes, many medicines that look like they're going to make it through the approval process end up not making it. So you spend, multiple millions of dollars on developing a drug that amounts to nothing because it fails in the final rounds of FDA testing or something like that. I know there were, I believe Baxter had a company called Bax Alta that split off from the original, roughly 5-6 years back, if I recall correctly. And that company, Bax Alta, had what they thought was a cure to Alzheimer's, or at least a treatment for Alzheimer's. And in the last round of FDA testing, it failed. Think about how many millions of dollars were spent on something that seemed like it was going to work, like it was clear cut, and how important a drug like that would be, and to have it fail in the last round of testing. That's why we have patents, because companies have to do that constantly until they find one product that makes it all the way through the approval process, so they can finally sell it. They have to recoup all that money. It has to be profitable for them, or else people won't invest this type of money to build, new medicines. If Joe Schmo down the street tomorrow can make a generic copy of it and sell it for way less, I'll never remake my money.
And that might sound a little harsh. I know a lot of people talking about the cost of medicine and calling for price controls maybe will say, why do I have to pay $20 for a pill that costs 5 cents to make? Because the first one cost $100 million, and the 3 times they tried to make it before that each cost $100 million. And so you're right, we could institute government price controls hypothetically and, make medication more affordable, but we would be done with new medications essentially. And I just think the economics are a lot more difficult behind a lot of this than people lead on, especially because the existence of price controls in other countries put more pressure on companies here to maintain their patent rights in the United States.
Well, absolutely. And what people don't realize, and this is crazy because most people can't even, perceive this concept, is that companies like Uber and even Amazon, until very recently, I believe Amazon is no longer doing this, but many of these extremely large companies have never turned a profit a day in their existence. They are still in the negative because of their costs up front. I think Amazon, over however many years Amazon's been running, the last 25 plus years or however long Amazon's been going, hasn't started turning a profit until I think the last 10 years. Don't quote me on that, but I think those are rough time periods for that.
Though you bring up Amazon, maybe we should move on to the next case that the Supreme Court denied a hearing for. Amazon workers were trying to appeal an appellate court decision. The facts of the case seem to be, and again, this is a case the Supreme Court will not be hearing, is that workers at Amazon warehouse facilities were undergoing security checks at the end of their shifts after they were clocked out that could take upwards of 25 minutes.
Which I think, if a whole week of that, it's roughly half an hour times 5 is what, 2.5 hours a week? Right.
And let's not forget that there is some precedent here that there's a precedent here. Companies are supposed to pay you for all of the work that you do, but if you clock out, there can be some final duties. If you clock out and then on your way out you arm the security system, they don't have to compensate you for that extra 2 minutes.
It just becomes too cumbersome to keep track of those few seconds. However, in the instant case, this is very interesting because, it's 10 hours a week. I mean, we can just use $10 as the minimum wage. Obviously, it's different everywhere. But even if it's just at $10 is the minimum wage, that's $100 a week you're missing out on.
$25 a week that you're missing out on? $100 a month, I think. 2.5 hours.
Yes, $100. Yeah. Excuse me, $100 a month.
Got a little math confused there, but yeah, $100 a month is significant.
This is why I study the law. Oh wait, I'm in business school too.
$100 a month though is significant, especially if somebody's working, full time in an Amazon warehouse at $10 an hour. That's a pretty chunk of change. And so yeah, while the first case, I think that I think I'm okay with that not being heard. I'm okay with letting the appellate court decision stand. I think that maybe the Supreme Court should have taken this one up.
I do too. I think it's kind of doing a disservice for them not to. It's quite a bit of time these people are losing, and as we talked about, some of the reasons the Supreme Court can reject taking up cases can be incredibly frivolous. There are times that the Supreme Court believes that a case has value, but believe it is not ready yet. What I believe what is it called when they say that there have been enough people.
Ripeness doctrine.
Ripeness. Enough people haven't sued over this type issue, so they're not going to take it up even if your case has merit.
Also, sometimes there's not enough controversy in the circuit, so there's different circuit courts regionally throughout the United States, and if most of them agree and they're doing the same thing, and maybe just some circuits haven't decided on this kind of issue yet, or only a couple are dissenting, they'll just say, yeah, well, people are pretty much doing the same thing anyway, so we'll let everywhere else be wrong. I do think there's some silly doctrines behind picking these cases. Next up, we do have another case that was denied certiorari, this time with Domino's. They were being sued, and the appellate decision was actually against Domino's, so they tried to apply for a writ for a lawsuit under the Americans with Disabilities Act, I believe.
Yes.
Some disabilities protection suit. It's not an employee. Oh, yes, it is under the Americans with Disabilities Act.
A blind man tried to use his text-to-voice program to order pizza from Domino's online, and I guess something with the app or the website, the mobile website,
Right.
did not work very well with the man's text-to-speak program, and so he's suing because he was unable to order pizza twice.
And here's the thing, too. It's not just that Domino's didn't do a good job implementing it. The suit is based on the idea that they actively ignored guidelines that do exist on how to make screen reader software interact better with your website. And so it wasn't just a poor try by Domino's. It seemed to be general disregard for these accessibility guidelines.
Well, I would strongly disagree with that. I mean,
okay.
Here, absolutely. I think the idea that that's frivolous is ridiculous. I hadn't even heard of these guidelines till today, and you could start a business. Here, if we were to monetize this podcast today, which is not monetized, if we were to monetize this today, we'd have a business. And if we had one of our website that we put up in accordance with this, supposedly if they found that Domino's was required to do this, that means our two-man shop right here of our faux business would be required to do this, or else we'd be liable about these guidelines we didn't even know existed.
The Americans with Disabilities Act does have a minimum threshold for how many employees you have to have before it's applicable to you. So we'd actually have a statutory exemption from the ADA. I want to say it's 20, but I'm not certain offhand.
Oh, 20. Excuse me.
I got you. You know, maybe it could be a bit draconically applied. I'll work on that phrasing, but I do think that the court might be operating on a bit of a sliding scale here. I do think at the point of Domino's, where I know people who design websites for places like Domino's. I don't know if he's done Domino's, but I think that they typically are very well aware of these standards. People who work in the web design industry tend to know what they're doing, and I'd assume that Domino's is hiring a professional web designer.
But I would also like to point out, currently, as it currently stands, these guidelines are not law. They're just merely a way to say that if you use these guidelines, your website should work with these different types of aids for people with different disabilities. What is being asked here is an extension of a law that predated the internet.
No, that's fair. Now, I don't think the issue isn't that they didn't comply with these guidelines, though. It's that their business model was so inaccessible to somebody, and ignoring these guidelines provides evidence, helps to substantiate their indifference.
Well, I think it's very interesting. So why don't we move on to our last denied case.
So the Supreme Court rejected one more case that we're going to look at here. There was a professional sports gambler named William Billy Walters, who had previously been convicted of insider trading, which was upheld by the appellate court. My first question of all is, how does one become a professional sports gambler?
You make a lot of money doing it, and that's all you do for your business.
I don't know, I'm pretty good at fantasy football. I got that Yahoo Platinum rating. I think I could get into this. I know how to call a football game. Anyways, the conviction resulted in a 5-year prison sentence for him, which tends to be pretty steep. A lot of these cases are usually decided on restitution and financial penalties. You don't get a whole lot of jail time for insider trading, as long as it's exclusive of fraud. But the allegation here is that Walters received inside information about Dean Foods Co., the dairy company, and Olive Garden, and he used that to make more than $43 million in profit.
Well, at least he can afford a good lawyer.
Well, that is an interesting question with these insider trading cases of what happens to the money. It's a very difficult formula to assess because you're speculating on what people did or would have sold differently and who actually lost money because they didn't have the advantage of this information being publicized sooner when he knew about it. The fact of the matter is that a lot of the calculations just go into assessing damages, and then the SEC tends to keep it. It's usually very difficult for people who would be victims of withholding this information, who made bad trade decisions because it wasn't publicized, actually being able to collect afterwards.
On another note, what does forfeiting $25 million mean? Because, I mean, Walters here was fined $10 million and ordered to forfeit $25 million. Was he forced to, like, give it to charity, or how does that work?
Yeah, so the fine is an actual criminal penalty, but the money that's forfeited is just money that he did not have a right to keep. And that's usually the amount. The fine actually goes to the Department of Treasury, I believe. All fines in government cases are going to end up there. But the forfeited money actually goes to the SEC. That is, in theory, like the pot that people who were disadvantaged by this insider trading scheme could try to collect from. With insider trading, that doesn't actually happen. It's too speculative. And so it kind of becomes SEC's money. Almost like if you had a civil asset forfeiture by a police department, they can usually keep that and use it to buy equipment and pay expenses.
Sounds like theft.
It's very controversial, actually. Forfeiture of assets is one issue where I know that everyone from the ACLU to the Heritage Foundation agrees that we need reform. It really just tends to be the law enforcement lobby that is standing by the current system.
Yeah, because it's theft. But let's move on. So the next thing we're going to talk about is we're going to talk about a case SCOTUS did pick up that is talking about trans employment rights. They picked that case up, correct?
Yes, they did. They actually picked up 3 cases on this issue. Sorry, they picked up 1 case on trans employment rights. They're also looking at 2 cases revolving to sexual orientation employment rights, let's call it.
And so far, the news seems to be that there is quite a few of the judges sympathetic to the argument that people who have sexual preferences, certain sexual preferences, would deserve protection under Title VII, which states that you're not allowed to discriminate based on sex. But the argument seems to be that with your sexual preference, you are being discriminated based on your sex, because it's not about whether or not if somebody likes a girl, right? If I'm a guy and if I like a girl, there's nothing wrong with that. However, right, if a girl happens to like another girl, then we're saying there's a problem. That seems to be I'm discriminating you solely in the fact that you're a girl who falls into this particular situation, which would be sex discrimination. I think that's a very appealing argument. I know there's some of the justices who disagree, and they disagree on intent grounds, but I think there's a room to argue against that too.
Right. Honestly, I'm surprised. I'm very much of the opinion, typically, that we just need Congress to decide more and the court to decide less on these kinds of issues. But I found that to be a very compelling argument that sexual preference, at least in the case of homosexuality, is about the sex of the person who likes somebody. And that kind of threw me for a spin, but once I heard it, I really came around. Interesting to note that based on the oral arguments, we don't know where the judges will end up in issuing their opinions or dissents, but Gorsuch said from the bench that sex definitely seemed to be a contributing cause, which, he's known to be a very conservative judge.
Which I agree. I don't know if any of the judges truly disagreed with that. What seemed to be the disagreement from oral arguments was what the intent of Title VII was when it was written. And this is where I think there's wiggle room, because the judges who disagree with this being sex discrimination, or disagree with increasing the protections to cover people's sexual orientation, seems to be that when Title VII was written, it covered a certain specific group of people with specific instances. And because homosexuality was not as big an issue then as it is now, that the people who wrote it didn't intend that. However, I would argue that while the authors may not have intended this to cover sexual orientation, they did intend Title VII to protect against discrimination based on sex. So whether or not they included who that person has a sexual preference for with their intent. They did intend to prevent it based on your sex, and therefore merely by having that would appear to have met that standard.
Right, and this is why I love justices like Clarence Thomas and Ruth Bader Ginsburg, because this is very much a case where I can see that one side is kind of labeled as the conservative position, but within that you have originalism, the idea that what was intended to be covered was not sexual orientation, and textualism, the idea that it says sex and sex is implicated here, so it should be protected. And so this is a case where I could see Clarence Thomas actually swinging to the left side of the court and throwing this in favor, and when a justice makes a principled stance like that, even though it is adverse to what you might think their policy considerations would be, I think that's what the Supreme Court should always try to do.
I would argue this even falls in line with originalism. It's just, what was the intent? The idea that...
Oh, so you're talking about different scope of intent.
Yes, because I would say that the intent was to protect against discrimination based by sex. Now, just because something wasn't thought of at the time does not mean it's not protected by the original intent. So, like, the argument that seems to be made here is that because the founders knew of cannons and muskets and a few different types of repeating rifles that did exist at the time the Constitution was originally wrote, because they hadn't imagined an AR-15, your argument would be, well, because they hadn't intended it to protect an AR-15, that they wouldn't be allowed, that the Second Amendment would not protect AR-15s, for example. I would argue, well, they intended to protect any arms that people could use against the government, and therefore, just because they couldn't conceive of what was as a modern AR-15 does not mean it's not protected. In this instance, just because they didn't perceive that people would change their sexual preferences, they still intended people to be protected based on this one factor.
No, so I think you're taking my understanding of originalism as more granular than it is, but I understand the distinction you're making. And that's an interesting point. So then the question comes then, in my opinion, to this transgender case, which I think isn't benefited by that textualist argument. Because the argument, at least as I understand modern gender theory, is that sex and gender are two different things. Well, the downside is that, or the consequence of that is that Title VII only protects against sex discrimination. So if the idea of transgenderism is based on changing your gender, then it, by its own definition, shouldn't fall into sex discrimination.
And I agree with this, and I think the issue here, I think there's two real questions. One, do we think, from a public policy standpoint, that transgender people who are transgender deserve rights against employment discrimination? That's the first question. The second question becomes, should the court be the person to enforce this if they find that that it neither textually nor was the original intent there when the Employment Rights Act was put together, when the Title VII was put together? Right,
which seems to be Alito's position on this, at least from the reports I'm seeing, is he's saying, yeah, it's really a shame that Title VII doesn't cover, in his opinion, either of these things. Congress should really make a law to change that instead of relying on the court to rule it. Which I definitely agree with that. Regardless, I don't like leaving these kinds of decisions up to the court, because precedent can change when the court changes precedent. So I think it was Clarence Thomas said that Supreme Court precedent is binding until it isn't. And so I think that regardless of how these cases come out, I would like to see an extension to Title VII, either an amendment or a new title come out to extend these protections statutorily.
I'm not quite sure that it's needed for people in the case of homosexuality or just sexual preference in general. I've already given my opinion on that, but I do think that something definitely needs to be put in there to deal with these kind of changing issues, or these issues that to update old laws so that they reflect our modern societies when necessary.
Yeah, no, I think that's definitely a respectable position, and I do think that in the past we've kind of seen that letting these kinds of decisions be made outside of the legislative sphere often backfires when the shift of power changes. It's really hard to undo legislation And so it just seems like a more durable backstop.
Well, we could sit here all day and lament how the judicial branch has been corrupted and twisted into a super legislature that it was never intended to be, which I think we both dismay at. However, now we're going to move on and talk about the legislature in that Spartacus, Cory Booker, has put forward a bill called the Federal Firearms Licensing Act. And I have a big problem with this bill, and I think you will too, so I'm going to tell you what it is. So the Federal Firearms Licensing Act would make it illegal to purchase or receive a firearm without a federal firearms license. Now, to clarify, there currently is a federal firearms license, but it only applies to firearms dealers currently. It does not apply to individuals. This bill would change that. So every individual, everyone listening to this podcast, who wanted to buy a firearm would have to have one of these licenses. Now, I think that alone is enough, but it only gets worse from here. So
more restrictive, let's say.
I'd say worse, but yes, restrictive works too. So we're going to start off a little tepid, right? So to even own a firearm, you would need to pass a safety course, an accuracy test, which I don't know how you'd pass an accuracy test without owning a firearm. I guess you're going to have to spend quite a bit at the range to get enough skills to pass the course.
Some people like me are just naturally great shots, so you don't know.
Yeah, I mean, you can't hit the broadside of a barn. And you also need to pass a written test of applicable laws, which of course is not defined because that would make it too easy. So whatever those applicable laws are, and I mean, I think it's difficult to navigate the laws of the United States and even the myriad of state laws. So I can only imagine what somebody who doesn't study law would figure out trying to navigate those. Also, they would require a person to get a background check, a criminal history check, and give their fingerprints. Now, someone listening to this might think that some of those things you already have to do. Currently you have to have a criminal history check, but you generally don't need to also have the background check. When we say background check for guns currently, what we're saying is there's a system in place that firearm dealers check to make sure you're not a felon. That's about it. The background check discussed in this bill is much more inclusive. And it would require you. It also require you to have your fingerprints taken. You'd also have to give the make, model, and serial number of any gun you plan to purchase, as well as the seller name. Now, the reason this is so much more stringent than the past system is because under this bill, everyone who buys a gun would be added into the FBI Wrapsback program. In the Wrapsback program, the records remain indefinitely, and they record your arrests as well, not just your convictions. And so this is a large change, and I think this is almost a due process issue here, because you could be discriminated against for things you weren't convicted for.
Yeah, this is actually kind of similar to my opposition to, there was an idea going around for a while, they called it no fly, no buy, which was if you're on the no fly list, you couldn't buy a firearm. Just like that, there's actually no, there's literally no minimum amount of evidence. There's no threshold of evidence you need to be placed on the no-fly list, and so there's no due process to remove your firearm. Right? There's some stories of senators putting their friends on the no-fly list as a joke, just to mess with them. And to think that a senator's joke could have your rights removed seems a little scary. To be arrested, similarly, almost no bar. You need probable cause, but
Well, and even then, even if there's no probable cause, it just means you're going to be released, and you're not going to be, and your trial won't exist.
Oh my God, you're right.
You'll still have been arrested.
Yeah, if you're wrongfully arrested, it doesn't say anything about actually correcting the record on that. Now, maybe you could appeal it though. Like if they withheld your firearms license for a prior arrest, and that prior arrest was a wrongful arrest, let's say, then you could appeal that, right?
I don't know. I mean, it depends whether they kept the record of the arrest. It's merely whether you're in the system, right? You would show you weren't convicted. I believe it also show you were arrested, at least in their record.
There's a general appeals process, right, for license denial?
Yes, we'll get to that in a moment, though. I'm angry that they even have you I'm angry they even have you give your fingerprints. I know for me, that was a big issue growing up. Like, I was like, well, I was interested in doing concealed carry, and as far as almost everywhere that allows concealed carry, except in states that allow constitutional carry, force you, when you get your license, to get fingerprinted. Now, that wasn't a huge deal for me because I've worked for the government as, a law clerk, and in the process of doing that, I had to get fingerprinted, so I was like, I'm already in the system. But for a lot of people, I can understand, ending up in a federal system with your fingerprints can be a little nerve-wracking.
Right. And maybe there's some compelling reason for that there, especially with a concealed carry license. You're taking a gun out and about. Being able to tie you to a crime, I can understand that there's some level of interest in the government there. But because my gun that I own, I have one for home protection, it literally stays in a box in my closet, locked. I don't know why they would need my fingerprints to be able to do that, because I'm not taking it out anywhere where it has a greater risk to possibly be tied to me committing a violent crime.
Now, if you're okay with all the things we already said, don't worry, it gets worse. So,
You're having a ball with this one.
Oh, yeah. So, your license can be denied because you have to go apply at, a local building. They don't describe what that is. I'm sure it's your local town hall or police station or something like that. So, you go apply for your license, right? And here's the reasons they can deny you. They give a myriad of different misdemeanor crimes you can be denied for, such as disorderly conduct, which is not a big deal, but there are some ones that maybe you agree with, like I believe they said illegal gun trafficking, whatever that means.
Yeah, supposedly touching a gun under this law would be illegal gun trafficking. I'm just not sure what the standard is anymore.
But there's other things like possession of drugs. So I mean, the only victim of that crime is yourself. But there's other things. There's other things here that I think are much more objectionable. You can be rejected if you've recently acquired other firearms or ammo.
Well, yeah, we can't have you buy guns if you're going to buy guns with that, right?
Absolutely. If you've had threats made against you, the applicant.
Not if you threaten somebody.
No, yes, not if you threaten somebody. If somebody threatened you. Obviously, this extends to if you make threats against other people as well, or if you've had a protective order given against you. Now, can you describe what the standard is for protective orders?
Okay, so I know that in Illinois at least, there are 3 levels of protective orders, and it's basically just a procedural question. First, if you're worried about somebody and you're going to be needing protection, you get an emergency order. If through preliminary hearings it seems like there's a real case, you get an interim order. As a resolution to a case, you can get a plenary order. But the way I read this law, even an emergency order would be enough. And to get an emergency order of protection against somebody, you basically just need to accuse them of something. There's certain things you need to accuse them of. There needs to be abuse, physical abuse, sexual abuse. You need to allege that it's escalating, or that it's systematic, or that they have a history of it. There's a few different types of allegations you can make, but just allegations all the same.
And the only way to overturn a denial is to file suit. You have to take it to a federal district court, which means you need to get an attorney and go to court. So I guess, poor people aren't allowed to own guns, because if they get denied, I doubt you can afford to do that, because that means hiring an attorney, spending the fees to go to court and whatnot.
So this kind of follows up on the question I had earlier, which is, if I'm wrongfully arrested and I hire an attorney and he gets me off because it was a wrongful arrest, there was no probable cause, and then I want to own a firearm, I need to get an attorney again to prove that arrest was due to probable cause, to try to appeal this order. It seems almost like I'm being tried twice here. This is not double jeopardy. It wouldn't qualify as that, but it's in violation of the principle, I think.
Sure, and that's only if you're denied, and I don't know if you'd be denied for an arrest. I know they track that under this, but it's certainly something to think about. Now, you might be thinking, okay, well, if I only have to go through this process once, I can deal with it. Well, you'd be wrong. The licenses expire every 5 years. Every 5 years.
Okay, but what if I get my license, I spend 5 years buying the guns I want, and then I'm done?
Well, the bill also takes care of that. It sets forth guidelines for the Attorney General to set up a system to retrieve your purchased firearms once your license is either revoked or expired. Oh, and now they know exactly what firearms you have because it's in a database, right? They've tracked every single firearm, make, model, and serial number that you've purchased. They know exactly what firearms you need to have. And I'm sure if you refuse to give it up, there will be legal consequences.
This was put forward by Senator Booker. He's running for president right now. I'm really happy that this might someday become just a campaign promise, because then it will never become law. We know that it's going to get followed up on.
And the last thing here that I just want to say, that the last relevant thing for this bill is that we're basically making private transfers much more difficult. Because under the current system...
Wait, what's a private transfer? Could you cover that real quickly?
Okay, so there's a couple types of transfers, right? There's two big ones. So I, as an individual, can go to a sporting goods store or a gun store, whatever, a place of business that sells firearms, and I can purchase a firearm from them. Usually many of these places are licensed dealers. Now, I can also find, online or whatnot, I can find somebody who's willing to sell me a firearm. So Bob down the street might own a rifle that I want, and I go, Bob, I'll pay you $100 for your rifle. We may come to an agreement, and we might transfer that.
Yeah, or your Uncle Jim could give you a rifle as a gift. Maybe he taught you to shoot when you were a kid, and it's like, hey, here's your old deer rifle. That's a private transfer also. Now,
under this bill, in order to do that, you'd have to go to an FFL, which is one of those licensed dealers. Now, these licensed dealers, their services aren't free. That means to even be gifted a firearm, or to, inherit one, you'd have to go to an FFL and have them transfer it to you.
Yeah,
which would cost money.
I have some pretty big reservations about this proposed legislation. One thing that you mentioned is, we're already seeing this in Chicago, where I'm at, with the concealed carry laws that we have already. It involves a very similar testing procedure almost, so far as accuracy and a written test. You need to take like 16 hours of course training. What they found looking at this since it's been implemented is that it hugely disproportionately affects the South and Lower West Side, the poorest neighborhoods in Chicago. If I'm living in some good neighborhood, Gold Coast or something, or Lakeview, sorry. People in those areas, the wealthy, affluent areas, have very, very little trouble complying with this. Actually, all the training facilities just happen to be in wealthy neighborhoods. And we're seeing not just a very low number of concealed carry permits being issued in poor neighborhoods, we're seeing an increase in firearm-based arrests in those areas. Some of them, I remember one case, I was actually working with police oversight at the time. A barber in the area, reputable citizen, he owned a barbershop in, I want to say South Shore, which is a low-income black neighborhood. He was the neighborhood barber, and he had a concealed carry, he had a FOID card, a firearm ownership card.
Which is ridiculous, but...
Not a concealed carry license. And we're not sure if it was just a misunderstanding with the law, what the law was, or if he just wasn't able financially to get a concealed carry card. But apparently he'd been having a lot of trouble with his shop, with security. He was worried about getting robbed. And so he was carrying his gun with him. And basically some police officers noticed this. There was an attempt at an arrest made. The facts get fuzzy at this point, but this guy got shot, and the argument was, at least from people who knew him, they said he wanted a concealed carry license, but he couldn't get one. And he passed away, unfortunately, because of the huge cost imposed to exercise his rights.
So what do we learn from this? Don't live in Illinois.
I think that's your takeaway from everything I say.
Well, it's not like you don't agree.
Fair.
Well, I think that's probably about the end of today's show. We should probably wrap it up. So, if you liked today's show, please give us a like, subscribe, or a review. We really appreciate you guys. If you have any questions, please send them to us at juristjargon@gmail.com. I hope you guys have a great week. We'll see you next week.
See you later.